Harper Paperbacks and Harper Monahan are proud to present How to Read the Constitution and Why by Kim Wehle. This is an Iliotibial Band Sleeps reading. Chapter 7. Crime and the 4th, 5th, 6th, and 8th Amendments. Amendment 4, 1791. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. The ban on unreasonable searches and seizures is one where the notion of privacy appears in the Constitution. The word itself is nowhere. Courts cannot issue arrest or search warrants without a sworn statement justifying them. Amendment 5, 1791. No person shall be compelled in any criminal case to be a witness against himself. This is where the notion of pleading the fifth comes from. Amendment 6, 1791. In all prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, and to be informed of the nature and cause of the accusation, to be confronted with the witness against him, to have compulsory process for obtaining witness in his favor, and to have the assistance of the counsel for his defense. The Sixth Amendment has rules aimed at making sure criminal trials are fair. Amendment 8, 1791. Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted. This is where the death penalty debate plays out. This chapter is about crime under the Constitution. The framers of the Bill of Rights cared a lot about fairness to criminal defendants and justice for victims, as demonstrated by the fact that 4 amendments to the Constitution address the topic. But it's not just the people who wind up prosecuted for crimes who find protections in the Constitution. It's anybody who lives in America and doesn't want the government peering into his or her personal business. The Constitution draws some very clear red lines here. It won't let the government knock down your door and rifle through your stuff willy-nilly, nor does it let judges give the go-ahead for that kind of thing by issuing a warrant without having a certain kind of evidence first. It won't let the government trump all charges against a political dissident and throw her in jail indefinitely. The Constitution contains language that won't let the government torture prisoners into confessing to stuff they didn't do, or force people to make statements that could land them in jail, and so on. Only government, not regular people, can press charges. Nonetheless, there are times when the government forces reluctant witnesses to take part in a prosecution against their will. As you know by this point, when the Constitution says thou shalt not do something, it needs consequences. There are bad cops, bad prosecutors, and bad judges, and cops, prosecutors, and judges who make mistakes. By affording individuals specific rights in the 4th, 5th, 6th, and 8th Amendments to the Constitution, the framers put tools in each of our individual backpack of rights, which we can take out to stop the government from doing something that it isn't supposed to do. How are these tools employed? Sometimes we can sue for money damages. Sometimes the evidence won't be available to the prosecution, i.e., a defendant can file a motion asking the judge to throw out a case or to ban the government from presenting certain evidence to a jury on the theory that, for example, the 4th Amendment was violated when the government searched the accused's iPhone and found incriminating documents. The Supreme Court held in 2014 that the police usually need a warrant to search data stored on a cell phone. Sometimes the government violates your privacy, and even though they can't use the information in a trial against you, there's nothing else that can be done. It is not unusual to read these days about how some cops cross the line and abuse people whom they pulled over for minor offenses, particularly if the suspect is African American. There are countless stories in the annals of American history about juries convicting innocent people as well. So obviously the Constitution doesn't protect everyone all the time. In each case, the Constitution works only if, at a minimum, the person whose rights were harmed went to court and demanded that the Constitution be enforced. And we've seen thus far, in construing the Constitution, judges often do some wild things, both for and against individual parties, that don't necessarily seem obvious from the constitutional text itself. This is what I call legal gray areas. Things are rarely clear-cut under the Constitution. But keep in mind that rulings under the Constitution can serve another function, in addition to making someone whole or stopping bad behavior before it gets worse. Decisions in individual cases create new rules, nuanced, fact-based threads delineating what behavior is acceptable and what is not, that guide the government's actions going forward. Consider a recent ruling by the Court of Appeals for the Ninth Circuit over the summer of 2018, which held that a Mexican mom could sue a U.S. Border Patrol agent who killed her son through a border fence in Nogales, Arizona. The court held that the officer who shot the 16-year-old multiple times, mostly in the back, violated the Fourth Amendment's ban on unreasonable searches and seizures. As a practical matter, all the court held was that the agent couldn't get the entire lawsuit thrown out. The mom still might lose the case later in the litigation, but this threshold ruling alone will likely change how Border Patrol agents brandish their firearms going forward. Bear in mind, though, that it's really hard to sue a law enforcement officer for violating the Constitution. To get money damages, a person needs to show that the officer should have known that what he was doing was constitutionally wrong. The behavior has to be something that was clearly illegal, and the wronged individual must show that a reasonable officer would know it was illegal. Look again at the text of the Fourth Amendment. It doesn't say much. As we've discussed, most of what constitutional law means is set forth in cases. Each case represents a different story involving different parties and different facts. Does this mean, then, that in the face of a constitutional lawsuit, an officer can simply say, "This exact thing never happened before, so I'm off the hook"? Not quite. Judges make the call as to whether, even if no court has exactly decided that that particular search of a car was illegal, for example, it might still have been obvious enough. If a hypothetical reasonable officer would not have known that a particular act is unconstitutional, if instead a reasonable officer could not have foreseen how a court would rule, the officer generally gets immunity. He can't be sued for what he did, period. In the case I just mentioned, even though the victim was a Mexican citizen standing on Mexican soil, the court held that any reasonable officer should have known that shooting and killing a person through the border fence is unlawful under the Constitution. Think about this. The court was not saying that the officer could be charged with murder by the Mexican government. Good luck extraditing him. The question was whether, by shooting a Mexican citizen who was standing on Mexican soil, an officer on U.S. soil could be charged with violating the U.S. Constitution. The victim was Mexican and in Mexico at the time, but the Fourth Amendment forbids unreasonable seizures. The court reasoned, and taking, i.e. seizing, a life with bullets counts even if those bullets land in Mexico. The counter-argument is that police officers can't do their jobs if they are afraid that well-meaning actions, even well-meaning mistakes, could bankrupt them in litigation later. If we expect law enforcement officers to read the minds of future court orders to stay out of trouble with the Constitution, then they might not act. Officers won't do what it takes to do the job of law enforcement if it means a parade of lawsuits. So again, it's all about balance. Balancing enforcement of the Constitution's requirements on one side of the scale, because without enforcement the document means nothing, and balancing on the other side the public policy implications of holding officers accountable for actions that in hindsight are unconstitutional. Fourth Amendment. 3 undefined words in the Fourth Amendment especially matter: unreasonable, search, and seizure. In 1791, the framers were worried about British soldiers searching through a family's home with no legitimate reason. Back in England, the monarch had access to such a thing as a general warrant. He could snoop as he pleased. The Fourth Amendment grew out of the framers' concern that indiscriminate searches and seizures conducted under the authority of general warrants were immediate evils to be avoided by, first, protecting the basic rights to be free from unreasonable searches and seizures, and second, requiring that warrants be particular and supported by probable cause. The Constitution's warrant requirement means that a search has to be cleared by a judge or magistrate, a sort of lay judge, in advance. The framers didn't want the government to be able to do a search just to see if there's something they can find. This is why they have to show a judge that there's no probable cause in the first place. What does the ban on unreasonable searches and seizures mean today? Back then, documents were kept in homes and private offices. They were written on parchment. There were no duplicates. Things were simpler. Nonetheless, to understand what search means, we might still begin with the meaning of the plain text. To search means to hunt or look for something. A woman drops an earring on an outdoor barbecue. She searches for it through the grass. We likewise understand the idea of a police officer searching a car or home office. A person in uniform opens a glove compartment or file cabinet to find a stash of drugs or an aha document that shifts the storyline of a particular case. What if the government takes someone's Facebook data and learns that he donated money to an organization that helps Syrian refugees? The government then connects that data with the other data it purchased from a data broker by applying a sophisticated algorithm. Based on the new information gleaned from that process, the government decides that the guy has a higher than average likelihood of becoming a terrorist. It knows that the man plans to be at a protest on the National Mall in Washington, D.C. next month, and decides to keep an eye on him. Is the government's use of that publicly available data to create new data about somebody, a very detailed portrait of that person's job, personal history, business, friends, financial history, purchasing preference, reading materials, interest, and beliefs, a search? The Supreme Court hasn't answered this question. A few more takeaways about the Fourth Amendment. The first is that the court has expanded the definition of search to include when the government violates a subjective expectation of privacy that society recognizes as reasonable. Let's stop for a moment to unpack the logic of this. The question is whether a reasonable person would expect that whatever the government probed would be kept private. There are two parts of this inquiry: whether the individual's subjective expectation was that a space would be private, and whether society in general would expect it to be private. For the second part, the court looks to a hypothetical reasonable person for answers about what the Fourth Amendment covers. If a reasonable person would expect privacy, then the government's probe constitutes a search, and the Fourth Amendment applies. Applying this text, the Supreme Court has held that a person has a reasonable expectation of privacy in a hotel room and in an old-fashioned phone booth if you can find one. But beware, there's a reduced expectation of privacy in your car. The reasonable expectation of privacy part, though, is running into trouble with that modern technology. Long ago, the Supreme Court declared that what a person knowingly exposes to the public, even in his home or office, is not a subject of Fourth Amendment protection. Thus, there is no reasonable expectation of privacy in an abandoned property, like garbage left out for collection, or in the movements of an automobile on public thoroughfares, because it is available for members of the public to view. There is no reasonable expectation of privacy in one's voice or handwriting, or in smells that can be picked up by a drug-sniffing dog during a routine traffic stop. Although the same dog picking up marijuana from your front porch is performing a Fourth Amendment search of your house, courts are very vigilant about protecting the core sphere of privacy that is your home. In short, if you make something public, you walk away from any Fourth Amendment protections. They are yours to lose, and if you choose to lose them, the Supreme Court won't stop you or let you put the genie back in the bottle later. Relatedly, the Supreme Court has held that the Fourth Amendment does not prohibit the government from obtaining information revealed to a third party. It's like telling someone a secret and saying, "Don't tell anyone." Anything you share with a third party cannot be expected to remain private. So the court has found that there is no Fourth Amendment ban on the use of information obtained through government informants. It also found no reasonable expectation of privacy in phone numbers dialed because callers voluntarily convey numerical information to the phone company. Providing tax documents to an accountant or records to a bank also relinquishes Fourth Amendment protections. One court has decided that there is a reasonable expectation of privacy in emails, but to date, no other court has agreed. So far, we've talked about homes get high Fourth Amendment protection and cars less so. What about cyberspace? With each click of a mouse and swipe on a phone, we turn over bits and pieces of information about ourselves to third parties. Are we giving up Fourth Amendment protections to that information? A CNN reporter bluntly described a typical person's cyber data trail back in 2012. Google has every email you ever sent or received on Gmail. It has every search you ever made, the contacts of every chat you ever had on Google Talk. It holds a record of every telephone conversation you had using Google Voice. It knows every Google alert you've ever set up. It has your Google Calendar with all the content going back as far as you've used it, including everything you've done every day since then. It knows your contacts list with all the information you may have included about yourself and the people you know. It has your Picasa pictures, your news page configuration, indicating what topics you're most interested in, and so on. If you've ever used Google while logged in to your account to search for a person, a symptom, a medical side effect, a political idea, if you've ever gossiped using one of Google's services, all of this is on Google servers, and thanks to the magic of Google's algorithms, it is easy to sift through the information because Google search works like a charm. Google can even track searches on your computer when you're not logged in for up to 6 months. Facebook has even more interesting stuff: your pictures, your comments, your likes, your friends, your unfriends. Under the reasonable expectation of the privacy test, The Fourth Amendment protects none of this stuff because we give it away voluntarily. Of course, we really do have no choice unless we go off the grid and live in a cave somewhere. The Supreme Court knows it needs to figure out what to do about this loophole in the law because Congress isn't regulating how our data trail can be used by the government or by the private sector. Technology is moving so fast and the Constitution just isn't keeping up. The court recently pulled back on the rule that you can't tell a third party you waive your Fourth Amendment rights. Although by signing up for a plan with Verizon and AT&T, people consent to sharing location data, the court found that getting that data requires a warrant. The next takeaway is a big picture one. The Supreme Court has identified an underlying goal of the Fourth Amendment that is broader than stopping government searches. It has recognized that the overriding function of the Fourth Amendment is to protect personal privacy and dignity against unwarranted intrusion by the state. In a case called Mapp v. Ohio, the court went so far as to characterize the Fourth Amendment as establishing a right to privacy no less important than any other right carefully and particularly reserved to the people. Emphasis mine. I raise this point because an actual right to privacy is nowhere expressed in the Constitution, and it's a major legal component of hot-button issues like abortion. Privacy is one of the soft norms that we've talked about before, values that are intrinsic in a good life and a society marked by individual freedom and liberty, but are not spelled out as a constitutional rule that can be enforced through clear terms. The final point about the Fourth Amendment is the warrant requirement. The idea here is that each search or seizure should be cleared in advance by a judge. To get a warrant, the government must produce documents or a sworn statement by an FBI agent or someone else that there is a certain level of suspicion of criminal activity by the person who is about to be searched. That level is known as probable cause, which varies slightly depending on whether we are talking about a search or an arrest. Probable cause to arrest means that there was a crime committed and that the person likely committed the crime, while probable cause to search means that it's likely that evidence of a crime is located in a specific area. There are a lot of exceptions to the warrant requirement, none of which are spelled out in the Constitution, particularly when it comes to searches of cars. A Supreme Court case, Carroll v. United States, created the vehicle exception, which permits police to search a car without a warrant as long as there is probable cause. Police can also detain people on the street without a warrant and can search and seize things in an emergency on the rationale that there is no time to get before a judge. We won't go into details here, but know that you do have rights if you are pulled over. Cops cannot search your car for zero reason, and if you are arrested, you get Miranda warnings telling you your rights, which the Supreme Court mandated in a case applying the Fifth and Sixth Amendments. If the cops don't do that, prosecutors can't use your statements against you at trial. But the bar to searching your car is not as high as the Fourth Amendment's plain language might otherwise suggest. The warrant requirement was in the news in 2018 with the search of former Trump lawyer Michael Cohen's home and office, as well as the government surveillance of Trump campaign foreign policy advisor Carter Page. People debated whether those searches were politically motivated, based on fake information, or otherwise improper. Missing from these debates was a discussion on the basic law governing how these searches came about. Both were done pursuant to warrants, which were signed off by Article 3 judges who were required under the Constitution to satisfy themselves that the government produced sufficient evidence of probable cause to search. Page's warrants implicated a statute that the Foreign Intelligence Service Act, or FISA, as well, but the idea is the same. Because judges cannot issue warrants based on speculation and political motivations, and judges take their job seriously, it's just wrong and hazardous to politicize that process, as many people have done recently, including members of Congress. We want federal judges to remain independent of political attacks and factual distortions. It keeps the process fair for everyone, and although judges can make mistakes and judicial procedures are oftentimes flawed, we should not be seriously wringing our hands about the federal judiciary these days. Judges are bound by a lot of rules, including that they have to apply the law and the facts of the cases before them. The facts can come only into that calculus if certain standards are followed. This is not the case with politicians. They can consider whatever comes across their desk or their computers, regardless of how reliable or unreliable that information is. This is a big distinction between judges and politicians, and one that preserves the integrity of our judicial system. Fifth Amendment. Now imagine someone is arrested for speeding. The police officer runs a search for the person's record and finds there are 3 outstanding warrants for the guy's arrest, 2 robberies and an assault. The officer puts the suspect in the back of his cruiser, gets behind the steering wheel, and says, "I see you have a record a mile long. We can do this the easy way or the hard way. I'll take your confession right now, and you won't get beat up in jail. Or you can pretend that you are innocent and face the consequences. You choose. If the suspect complies and confesses to the robberies and assault, it could go one of two ways for him. The suspect could go to jail even though the police officer got him to confess by threatening him with physical violence. The threat violated the suspect's Fifth Amendment right not to incriminate himself. The Fifth Amendment embodies the notion that we don't want the government to be able to bully people into admitting things that they did or didn't do, if the penalty is jail. And remember, that's the big difference between a civil case and a criminal case. A civil case can't land someone in jail, but because the suspect didn't pull out the Fifth Amendment tool from his backpack of individual rights, under my hypothetical, the Constitution would remain unenforced. The cop would either get away with it, and future cops might get away with it too. The other way it could go is that the suspect gets a lawyer who reads the confession and hears from her client that the confession was coerced with a threat. First off, the lawyer would call the government and tell the prosecutor that this is a bunch of BS, but let's assume that the government won't budge. When the suspect is later brought before a court by the government on formal charges of robbery or assault via a piece of paper called either an information or an indictment, the latter being something that is issued by a grand jury, the defense lawyer would enter a plea of not guilty. If the government takes the case to trial anyway, the endeavors to introduce the confession into evidence, the defense lawyer would then move to exclude it because it was obtained in violation of the Fifth Amendment, something known by lawyers and judges as the exclusionary rule, which also applies to an unlawful searches and seizures under the Fourth Amendment, as well as the failure to give Miranda warnings. The tool would come out of the backpack, the judge would likely grant that motion. The government would then have to either drop the case or come up with better evidence of the suspect's crimes. If the case is dropped, the guy walks free. A few additional notes about pleading the Fifth. Technically, this issue comes up when someone is brought before a grand jury or at trial to testify about her knowledge regarding a crime. When the question is asked that if answered would get the witness in criminal trouble, she can refuse to answer it unless she gets immunity. If she gets immunity from being prosecuted for related crimes or having her testimony used against her later, she can be compelled to testify. At this juncture, the question becomes what? What's the penalty for not talking to a grand jury? I.e., what's the equivalent of the threatened violence in my speeding hypothetical? The answer is contempt. This topic came up with the special counsel report Robert Mueller probe of Russian interference in the election. If President Trump receives a grand jury subpoena and refuses to testify, then what? Well, the matter would go before a judge. Either the witness would move to quash or kill the subpoena altogether, or, in my hypothetical, if she refuses to answer, the government would file a motion asking the judge to hold the witness in contempt until she testifies. This can literally mean going to jail. Happened to a woman named Susan McDougall in the Whitewater investigation by independent counsel Kenneth Starr, on which I worked. In both instances, whether a motion to quash or a motion for a contempt order, the judge would be deciding whether the Fifth Amendment tool applies to protect the witness from having to say things that hurt her. Note that pleading the Fifth is generally done on a question-by-question basis. Answering "what's your name" is not an issue that could normally incriminate a witness. Answering "did you pull the trigger of the gun" is one that would. Answering "did you pull the trigger of the gun" is one that would. So the Fifth is not a blanket protection. For Trump, it's a bit different. There's an argument that he gets blanket protection on separation of powers grounds because he's the head of the executive branch. But for regular people, that argument does not apply. Some people criticize the very notion of pleading the Fifth as some sort of cop-out, but it's in the Constitution for a reason, to protect individuals from being unfairly bullied by the government through criminal justice system. The notion that a person can plead the Fifth just to avoid answering uncomfortable questions, even if there's no criminal liability for doing so, is also a bit dodgy. Most people won't do it just for the heck of it, because it looks really bad. It looks like a person has something to hide. It also turns out that the Fifth Amendment privilege only kicks in if you actually have stuff to hide. So imagine that you are a witness in a grand jury investigation who was an accountant for a defendant who is charged with tax fraud. Yes, I'm referring to the 2018 trial of former Trump campaign chair Paul Manafort in the Eastern District of Virginia. A number of those people who testified initially pled the Fifth. Your invocation of the Fifth Amendment privilege gets to a judge, either by your motion to quash a subpoena or via a government's motion for an order holding you in contempt for refusing to testify. Either side, in other words, can bring the issue before a judge. You will need to tell the judge that your claim is legitimate, meaning that you have to show your cards privately to the judge as to what you would say if forced that would get you in trouble. If you are fibbing, the judge won't let you plead the fifth. He will deny your motion or grant the government's, and you could go to jail unless you agree to testify. Again, if you are compelled to testify after pleading the fifth, by contrast, the government will often give you immunity from prosecution later, so your statements cannot be used against you. In that event, you can't get away with refusing to testify anymore. There's no legal danger in you doing so. Sixth Amendment. If the Fifth and Fourth Amendments are about events prior to a criminal trial, then the Sixth Amendment covers the trial itself. Here's what goes into the accused's backpack for that process: a speedy trial, a fair jury, an attorney if the accused person wants one, and the chance to confront people who are accusing that person of a crime. Let's tease this list apart. Speedy means that the government can't leave you in jail for months or years while it actually gets around to proving in a jury trial that you did what it says you allegedly did wrong. Imagine that you are not guilty of any crime, but a crooked cop arrests you and a crooked prosecutor charges you, and they know they can't convict you, but they want the community to think they got the man responsible for, say, a brutal murder that has gone unsolved and is making the public restless. So they catch you and lock you up. They secretly plan to throw away the key and never actually go to trial, but they tell you they're just backlogged and will get around to proving why they have the right to put you in jail at some point soon. The Constitution says get on with it. Most judges allow both sides of a case to take the time at trial that the judge believes they need, at least, but not unlimited time. At some point, the government needs to either prove its case against you or let you go home. That said, the practical reality is that lots of people are incarcerated, often for long periods of time waiting for trial. They can lose their jobs and their homes in the interim, all the while being innocent until proven guilty. That phrase is about the government's burden of proving crimes. It's not itself a right in the Constitution. Generally, poor people and their families are more likely to suffer these kinds of harms than are people who have the money to make bail. As for the jury, it has to be impartial. That means that the government can't put a murder victim's entire extended family in the jury box and expect them to fairly hear the evidence against the alleged murderer. And it can't have people in the jury box who think all murders should be executed, or something else along prejudicial lines. That's not fair. The lawyers and the judges will go through a Q&A process called voir dire, which derives from the French language and today means to see, to say, to find out whether the jurors are biased or whether they can fairly consider the evidence in a neutral fashion. Of course, as one can imagine, this process is more of an art than a science. How often do you think the question, "Do you all promise to be fair and impartial," will actually produce an accurate response? I mean, who is going to say no to that, except as an excuse to go home? Most lawyers realize that they need to be more strategic in asking subtle questions that get at this issue in other ways. Note that some cases get tried before a judge, not a jury, even criminal cases. They're called bench trials, and for those, judges need to be impartial too. However, just because someone in the jury pool is a mom, or a Republican, or an African American, or wealthy, etc., doesn't mean that she will stereotypically go one way or another on the ultimate issues in the case. Juries are funny things. When you think about it, they are exquisitely democratic. They are arguably the most democratic institutions we have these days, because regular people get to decide matters of immense importance. Think about a jury trial of a member of Congress accused of insider trading. If the jury convicts, the message is clear to all elected leaders that this kind of thing is not going to fly. Juries are made of regular people with their own unique experiences. We know from our own personal day-to-day relationships that people, even those close to us, can surprise us. For attorneys and judges, juries are no different. A few final points about the Sixth Amendment. The Constitution says that the government can't have secret witnesses lodge accusations against you. You generally get to probe those folks face to face, or your lawyer does, or their testimony stays out of the trial against you. Again, it's all about fairness. The Constitution also says you get to force the accuser to come to court and air their grievances against you before a neutral decision maker. Finally, if the accused wants his own attorney, the government can't say no, and if he can't afford one, the government must pay for one. This is important because it means that the government can't ambush someone by leaving them defenseless at trial. Lawyering is not easy. Anyone who tells you the opposite is lying. It can't be done well without a law degree. In 1963, the Supreme Court extended the right to a free lawyer to state prosecutions. Sadly, as a practical matter, in many states the right is a fiction because there just aren't enough public defenders to go around. Moreover, it's not clear when the right to free counsel attaches. Does a person immediately get a free lawyer after he is arrested and receives his Miranda warnings, i.e. the right to remain silent in speech? No. How about for an appeal of a death penalty sentence? No again, although some states' constitutions provide for a lawyer post-conviction. The Supreme Court has stated that a defendant gets a lawyer at or after the time that the judicial proceedings have been initiated against him, whether by the formal charge, preliminary hearing, indictment, information, or arraignment. But that doesn't mean a paid one. A good defense lawyer can cost upward of $100,000 to try a murder case. The constitutional right to have a lawyer at your criminal trial is one that benefits rich people more than poor people, to be sure. It's not just the lawyer's time, but the time of experts, investigators, jury specialists, audiovisual specialists, and on that can suck up a lot of money. Under an ideal budget, the defense team conducts a mock trial of the entire case before a mock jury to work out any kinks. Imagine the cost of paying people to act as jurors, prosecutors, and everything else. Bottom line is, it's very good to have access to a lot of money if you are accused of a crime. Eighth Amendment. Finally, the Eighth Amendment. It's something that every American should know about for one key reason. We have a death penalty in the United States. This is a big deal for the obvious reason that taking a life is morally problematic and pretty much is the most severe kind of punishment imaginable. That's all assuming that punishment is a valid endgame in the criminal justice system. Some argue that rehabilitation should be a goal as well. But that as it may, the other reason that the death penalty is a huge deal has to do with the government power. It's the government that's taking a life here, and it's often taking the life of an American citizen for reasons that have nothing to do with, say, national security, unlike soldiers who kill enemies or civilians on foreign battlefield, for example. As we've discussed, the Constitution contains rules limiting the government's ability to act arbitrarily and unfairly when it comes to investigating and prosecuting crimes. But people in charge of these things get them wrong, both deliberately and mistakenly. And when they get it wrong, it can only be fixed if an individual is willing and able to bring a claim before court. The tool has to come out of the backpack for that process to work. So, in addition to lots of other arguments against the death penalty, the question to keep in mind for present purposes is one that we've been talking about throughout this book. How much power should we allow the government to have over our individual lives, liberty, and property, among other things, before it becomes too much? And is it really no answer to make the death penalty other people's problems? On the assumption that it can never happen to me, lightning strikes innocent people too. Even though most of us will escape the death penalty, we can't escape government power, so we have to be careful about how much of it accumulates. It can be used against our interest in other ways, a fait accompli before we are even aware of it. First, a few Eighth Amendment basics. The Constitution bars cruel and unusual punishment of people held in jail or in prison. But what is cruel? What is unusual? Should courts confine themselves to what is uncommon and considered cruel in 1791? To be sure, the phrase bans medieval practices like torture, burning at the stake, and crucifixion, but even here it gets tricky. We saw this with the debate over waterboarding of suspected terrorists during the George W. Bush administration. Is simulated drowning torture? Most modern Americans would think so, but the famous torture memos out of the DOJ under George W. Bush concluded no, nothing is torture. If it doesn't produce near organ failure, a suspect might feel that he is drowning and therefore confess in sheer terror for his life. But so long as the procedure stops short of actually killing him, the government's official analysis went, it's totally fine. Bush ultimately agreed that waterboarding is not acceptable, as presidents have before him. It might come as a surprise to some people, however, that prisoners in the United States can be physically beaten by prison officials without necessarily violating the U.S. Constitution. Guards can also take physical violence too far for the Eighth Amendment, of course, but remember that there's no consequence when that happens. If the prisoner can't persuade a court to honor his Eighth Amendment tool in his constitutional backpack, the bad behavior will continue. Excessive force claims under the Eighth Amendment also require that an inmate prove that physical force went beyond what was needed to maintain order. Prisoners are shackled and forced to move in certain ways and to certain places every day. When does maintaining order cease to become maintaining order and move into cruel and unusual land? Again, you won't find the answer in the Constitution's text. In 1992, the Supreme Court considered what it means by excessive force in a case involving handcuffed and shackled inmate who was beaten in plain view of a supervisor. The court rejected the government's argument that no Eighth Amendment violation occurred unless the prisoner showed significant injury. A minor injury suffered. Still, it held that the prisoner must show that the force was used maliciously and sadistically to cause harm, rather than in a good faith effort to maintain or restore discipline. As one can imagine, it's very hard for prisoners, often without a lawyer and without access to prison records and other information in the government's possession that might help prove their claims, to show that a guard doesn't use force for disciplinary reasons, but instead acted out of malice or sadism. The government will always make the argument that force was justified. The cards are stacked against the prisoners, but the counter-argument is that if it were easy to bring lawsuits against prisons over how prisoners are treated, prisons would not be able to function. Correctional officers would be so tied to acting with kid gloves that they wouldn't be able to maintain discipline, and prison resources would be overly invested in litigation. Violence in prisons isn't the only place the Eighth Amendment's ban on cruel and unusual punishment shows up. It's often raised to rectify harsh conditions of confinement and has been extended to things like vermin-infested prisons that lack toilets. The standard that prisoners have to satisfy is one of deliberate indifference. Words that are nowhere in the Constitution, unsurprisingly. Deliberate indifference is a standard that's hard to meet because it requires proof that prisoners' officials knew of a problem and they deliberately chose to do nothing. Showing that rats are in prison cells is not enough. An inmate must show that prison officials knew about the rats and deliberately chose to do nothing. This kind of showing requires the plaintiff to come up with evidence that essentially climbs into the brain of another person, which is always hard to do. Keep in mind, moreover, that for prisoners to bring claims in court, they first must exhaust their administrative remedies. What this means is that there are a lot of procedural hoops that they must go through within the prison's bureaucracy before they can even attempt to get before a judge. They have to complain first to the prison, and that complaint process includes filing on time whatever internal prison appeals are required, and they have to dot their I's and cross their T's when doing these things. If they don't, they can't be heard in court, even if their claims are legitimate. The rationale here is that if prisoners have to run things by the warden first, maybe prisons will do the right thing and fix problems without having to bother the courts with the dispute. As with any balancing test, however, the rub is that the prison's procedural hoops can't be so complicated that it's virtually impossible for prisoners to meet them. The Supreme Court has held that for constitutional claims, the hoops have to actually facilitate a resolution of the prisoner's complaint. As a practical matter, the hoops can be complicated even for novice lawyers, let alone inmates, who may lack even a high school diploma, and the law doesn't care much. Now for the death penalty. Except for a brief period in the 1970s, the Supreme Court has not considered death to be cruel and unusual punishment under the Eighth Amendment. This should have come as no surprise because we all know that it's illegal to execute people in the United States, in 39 states to be more precise. And the federal government, more than 1,490 have been legally executed since 1976. By this point in the book, this fact of life in America might raise some new questions in readers' minds. How is it that killing someone isn't at least kind of cruel and unusual, in that it doesn't happen every day in America, and it doesn't happen at all in most countries around the world? In 1972, the Supreme Court held a case called Furman v. Georgia that the death penalty is not cruel or unusual, but that it was being implemented in really awful ways. Burning and bludgeoning has stopped in the early 19th century, but the way executions were going down in the 1972s was considered freakish and wanton, in the words of concurring Justice Stewart, who noted that the imposition of the death penalty is cruel and unusual in the same way that being struck by lightning is cruel and unusual. The court accordingly told states to clean up their acts and change the way they killed people so as to comply with 4 criteria. The manner of execution can't be degrading to human dignity dignity, it can't be arbitrary, it can't be rejected throughout society, and can't be unnecessary. Here again, these standards do not exist in the text of the Eighth Amendment itself. In 1976, the Supreme Court looked into how the government was killing prisoners in America under Furman's criteria and signed off on death penalty statutes that had been enacted by 35 states. Since then, the court's scrutiny of executions under the Eighth Amendment has focused on the how instead of the whether. The how has included firing squads, the gas chamber, hangings, lethal injections, and electrocutions. Electrocutions mostly fell out of favor at some point on the rationale that lethal injection is more humane. But there have been many instances in which inmates suffer horribly due to ineffective drugs. Does one botched execution condemn the entire practice as cruel and unusual? Part of the problem now is that drug manufacturers are refusing to sell the particular chemicals that go in the cocktail used on death row, so states have to consider other options, which may or may not work. If they don't work properly, the execution can become ugly and mean. A few other things to keep in mind when considering whether, on balance, the way we execute people in this country is constitutional, or even if it is constitutional, worth doing as a policy matter. Since 1976, 144 people have been released from death row on grounds of innocence. That's 10% of the total number sentenced to death. If we assume that some people aren't making it all the way to proving innocence through the appeal process, which is an entirely fair assumption given what we know about how hard and expensive it is to prove things in court, particularly without a lawyer, it means that the government has killed and will likely continue to kill innocent people. Statistics show that the death penalty process is very expensive for taxpayers, with death row costing more per year than life in prison, and that it doesn't really deter people from committing offenses that carry the death penalty. They also suggest that geography, southern versus northern status, race, gender, and the ability to afford a lawyer, i.e. wealth, all come into play regarding whether someone is executed by the government rather than the heinousness of the actual crime relative to other crimes. In this connection, the death penalty has triggered other constitutional problems, primarily under the Equal Protections Clauses, but so far the Supreme Court has rejected them. Eye for an eye, retribution is on the other side of the scale, to be sure. Some people will say that certain crimes are so awful they must have execution as an option. And even if a few stray people get killed by mistake, and even if people of color are disproportionately executed, it's too bad. But making sure we are harsh on really awful crimes is too important to give up. But even on that metric, the statistics don't line up. Really scary criminals sit in jail for life. Others have been executed for being entangled in a murder that they didn't actually commit. Statistics show, moreover, that a majority of Americans don't care whether a politician opposes the death penalty. There isn't strong public support for it, and internationally, the United States trails only 5 countries in the number of executions from 2007 to 2012: China, Iran, Saudi Arabia, Pakistan, and Yemen. And that was Chapter 7 of How to Read the Constitution and Why by Kim Wehle.